Hey everybody, back this week to talk to you about what happens after a final judgment is entered in a family law matter, whether it's a paternity action or a divorce action. If you've been watching our series and saw the PEACE acronym, the PEACE series that we went through, you learned about the components of a divorce in general, as far as what the court has jurisdiction over, as far as issues that they're hearing in a divorce. So just real quick, it's parenting, equitable distribution, alimony, child support, and everything else, or PEACE. So of those items, the court has jurisdiction after a final judgment is entered, if it retains jurisdiction in the final judgment, to modify some of those. The court can modify issues relating to parenting, they can modify alimony, and they can modify child support. Generally, the court does not retain jurisdiction to modify equitable distribution, which is how the marital estate has been distributed to the parties. Once those property rights have been established in the final decree, usually that's it. So I'm going to go through what can be modified, because each one is a little bit different as far as what the court's looking for when you're seeking a modification. But before I touch on those procedurally, you have to file a petition. So not a motion, but a petition, which means you need to file it with the clerk. You need to get a summons issued. You need to have the summons served on the other party. That party's got 20 days to respond. There's a discovery requirement for both parties to exchange certain items mandated under 12.285 of the Florida statutes, which deals with mandatory disclosure. So it's very similar to an original proceeding in that way. It's not just kind of something you can do by a motion, or a lot of times people tell me they want to write a letter to the judge. It doesn't work that way. You got to file a petition. So parenting, this is the one that we spend the most time talking about modifying, and specifically time sharing. So there's a statute that deals with the requirements, and then there's a very famous case that we always talk about, Wade versus Hirschman. I don't think that case is getting changed anytime in the near future, so I don't have a problem mentioning it here in this video. But it basically says that there needs to be a substantial, material, and unanticipated change in circumstances for the court to modify a final judgment. And the case law has said that this is an extraordinary burden on the party seeking a modification. There's a whole list of things that the court doesn't consider substantial. Things like someone getting a different job, someone relocating by itself isn't enough. One incident of violence, one incident of drug abuse. There's got to be something pretty major, either in and of itself or in the aggregate of a number of events. So not only that, but it's got to be material to what the case, the final judgment ordered, meaning what the event was has to do with something that the court previously ordered. And then finally, that it's unanticipated, meaning it wasn't something at the time that you entered into the final judgment that the court felt was it could have been anticipated by the parties. So that's the first prong. Then the second prong is that the modification that you're seeking has to be in the best interest of the children. So you may say something, pretty severe has happened, but then what you're requesting doesn't make any sense for the child. You've got to be always focusing on what is best for the child. So for time sharing cases, modification, you got to show those two things. Next is alimony, if we're following the acronym, the PEACE acronym. So for alimony, the first thing you got to determine is, pursuant to the final judgment, did the court call it modifiable or non-modifiable? Because if the court called it non-modifiable, it's much more difficult to touch what the court ordered in alimony. But usually the court says it's modifiable and will terminate only upon the death of the paying spouse or the receiving spouse entering into a supportive relationship. Basically, that they have now begun to reside with somebody else, and that party is supporting them financially somehow. The court can modify alimony when it's modifiable based on a change in the income of either party. Usually we find that it's the change in the income of the paying party that is more germane to that analysis by the court. We don't see so often an upwards modification of alimony. Usually the only times that we'll see that is where the original order of alimony was lower than what the party that was seeking alimony had a reasonable need for. So maybe in some circumstances when the parties got divorced, they weren't financially in the best position as opposed to what they had been during the marriage. And so the party seeking alimony may have agreed to a lower amount than what they were actually asking for at the front end. If the paying spouse rebounds financially, the party receiving alimony can come back and say, I would like an increase, and in some circumstances the court will grant that. More often what we see is either the receiving party enters a supportive relationship, as I just explained, or where the paying party wants to retire. The case law does support that someone paying alimony is allowed to retire and therefore reduce their alimony payment. Usually when we see alimony modifications, it's with permanent periodic alimony. There are some circumstances where durational alimony can be modified. Usually it's to the amount, not to the duration, but in any event, usually it's with permanent periodic alimony awards that we see a modification. Finally, and probably a tie for time sharing as far as most often modified, is child support. So child support can be modified based on a change in the income of either party. And that can both be not only what they pay, but also if their medical insurance changes or some of the other things that change what their net pay might be. There's a basis there to modify. You have to show that the change is involuntary, permanent, and that the child support amount will deviate by either 15% or $50, whichever is greater. So you need to establish all those things for child support to be modified. With both the alimony and the child support, those modifications, the court has jurisdiction to modify retroactively back to the date that you filed the petition to modify. So let's say hypothetically you filed to modify November 1st of 2019, but you didn't have a trial until the summer of 2020. Well, the court at that point can come back to November 1st of 2019 and say it should have been modified upward or downward, depending on the circumstance, back to that date. They can't go back prior to that date. So these are all circumstances under which, even after a final judgment is entered, that the parties can seek a modification as to these terms. So if you're looking for an attorney to help you with the modification of your final judgment, be thinking of these things. Make sure to ask whoever it is that you're consulting with about these things. Make sure that they understand what they're talking about, because I can't tell you in my experience as an attorney how many very poorly written modification petitions I've seen that really just don't cut the mustard as far as what the courts require. And you're setting yourself up to spend a lot of money unnecessarily if you're not doing it right from the outset. So if you have any questions, please give us a call at the office. Check us out online. We've got Facebook, Instagram, YouTube, all that good stuff. And I'll see you next week.